Can a trust be a person? Lessons from the New Zealand Supreme Court for offshore trust practitioners. On the 13th of May 2026, the Supreme Court of New Zealand granted leave to appeal in RH and JY Trust versus WorkSafe New Zealand and considered whether a trust and/or the trustees of a trust acting collectively constitutes a person for statutory purposes. Although the case arises under New Zealand's Health and Safety at Work Act 2015, the underlying question, whether a trust can bear obligations and liabilities as if it were a distinct legal entity, raises interesting questions about the nature of trusts and trustee liability that are likely to resonate across common law jurisdictions. Background. A tragic accident took place in September 2020, where a young child lost their life as a result of injuries sustained on a farm owned and operated by the RH and JY Trust. At the time, the trust had 3 trustees, 2 individual trustees, once since deceased, and Perpetual Trust Limited, a corporate trustee appointed only 5 weeks before the accident. WorkSafe New Zealand, the workplace health and safety regulator, brought criminal charges under Sections 37(1) and 48(1) of New Zealand's Health and Safety at Work Act 2015 against both the trust itself and, in the alternative, the trustees collectively. The trustees challenged whether charges could validly be brought against the trust or against them as a collective, as distinct from charges against each trustee individually. The journey through the courts. The case has produced a striking divergence of judicial opinion at each level. The District Court. In the District Court, Judge Bidwar held that no charges could be brought against the trust or the trustees collectively, reasoning that a trust is not a person and cannot be held liable for the actions or failures of the trustees of the trust. On this view, only the trustees in their individual capacities could be defendants, and the charges against the trust were dismissed. The High Court. Harvey J. allowed WorkSafe's appeal in part. He accepted that, notwithstanding the orthodox position that a trust is not a separate legal entity, the position can be displaced by specific legislation, and that the orthodox position that a trust is not a separate legal entity is relevant but not determinative. He found that it would be a perverse outcome if 3 loosely associated persons carrying out business with an informal structure could collectively be a person conducting a business or undertaking, PCBU, but 3 trustees holding business assets in trust could not be. However, Harvey J. concluded that the correct defendant was the trustees collectively, not the trust itself, preferring an interpretation that accords more closely to civil law and to reality. The Court of Appeal. The Court of Appeal's decision was a 2-to-1 split. The majority, Cook and Palmer justices, held that a trust, or its trustees acting collectively, can be a person for the purposes of the Act. Water justice dissented. Cook J., delivering the majority judgment, acknowledged the force of the argument that concluding that a trust is a person who can be charged with an offence is apparently inconsistent with well-established principles of trust law. A trust is not a legal person. It is essentially a set of equitable obligations that the trustees have. Nevertheless, the majority held that, whilst trust law creates a very strong starting point for addressing the issues of interpretation that arise, it is not determinative. The majority's reasoning rested on several pillars. The definition of person in Section 16 of the Act includes the Crown, a corporation's sole, and a body of persons, whether corporate or unincorporate. The majority reasoned that these definitions extend who can be a PCBU to unincorporated bodies of persons, and that questions of legal form are not determinative. It depends on who is conducting the business or undertaking as a matter of substance. The majority also relied heavily on Discount Brands Limited versus Westfield New Zealand Limited, 2005, NZSC 17, where Tipping J observed that, by making unincorporate bodies persons for Resource Management Act purposes, Parliament seems to have been looking more to substance than to legal existence or form. The court also drew on Cometa United Corporation versus Canterbury Regional Council, 2007, NZCA 560, which held that unincorporated bodies with collective decision-making structures and pseudo-corporate features can be prosecuted as bodies of persons. New Zealand's Health and Safety at Work Act 2015 prescribes different maximum penalties depending on the type of person who is the PCBU. For individuals who are not PCBUs or officers, the maximum fine under Section 48 is $150,000. For individuals who are PCBUs or officers, $300,000, and for any other person, $1.5 million. The majority considered it contrary to Parliament's intent to conclude that the maximum penalty in Section 48(2)(c) is not available when the collective decision-making body is a trust rather than a company, partnership, or similar body. The definition of officer in Section 18 refers to a body corporate or an unincorporated body other than a company, partnership, or limited partnership, and to any person occupying a position comparable with that of a director. The majority held that this shows Parliament's intent to comprehensively address, in a harmonised way, all legal structures that might be employed in the undertaking of businesses to which the duties of the Act attach. Section 29 of New Zealand's Health and Safety at Work Act 2015 prohibits indemnification for liability to pay a fine which, in majority's view, was fatal for the appellant's argument. The majority held that this prohibition would prevent trustees from being indemnified from the assets of a trust. As a consequence, the majority held that trustees cannot be indemnified from the assets of the trust, and they would face personal liability in a way that is inconsistent with trust law principles. The trust assets would be effectively immune, notwithstanding that it is the trust assets that should be at risk, given that the trust has engaged in the business. Treating the trust itself as the liable person solves this problem. The penalty falls directly on the trust fund. The majority further held that either label could be used to identify the collective body. The trustees could be named in their capacity as the trustees of the trust acting collectively, or the trust itself could be named. The important point is that, if the trustees are named to identify the trustees are not defendants in any individual capacity. Waterjay's dissent was anchored in what he described as fundamentals and rules made over centuries, which he listed as follows. A trust is an equitable obligation, not a person. Trustee liabilities are personal. Trustees are entitled to be indemnified for expenses paid or liability incurred while discharging trustee responsibilities. Waterjay rejected WorkSafe's substance over form argument as a category mistake. Every action by a trustee using trust assets is premised on the rules of trust law just mentioned. Trusts and trustee collective entities do not exist as persons. Individual trustees and only individual trustees conduct business using trust assets in law and fact. That is a matter of substance, not form. On the indemnification question, Waterjay disagreed with the majority, asserting that Section 29 prohibits indemnification by another person, and, as a trust is not a person, the prohibition does not apply. A trustee is not being indemnified by a person because the trust is not a person. Waterjay argued that the trustee is in no different position to that of the sole trader who invests their own money to pay business-related liabilities. Waterjay proposed an alternative solution. WorkSafe may prosecute a defendant as trustee with payment of the fine out of the assets of the trust. This approach gives vent to the statutory purpose without doing serious violence to orthodox conceptions of individual trustee liability or the nature of trusts. Trust law, he argued, provides a ready-built, coherent regime for making trusts pay for doing business through individual trustees. The dissent also emphasized the criminal justice dimension. Criminal liability attaches to individual responsibility and individual culpability. Trustee liability should be tied to the individual culpability of the trustee when acting in that capacity, allowing fines to correspond to the nature and severity of the breach by individual trustees according to their individual level of culpability. The Supreme Court's grant of leave. The Supreme Court granted leave to appeal in a short judgment, framing the approved question with precision, whether a trust and/or the trustees of a trust, acting collectively, is a person within the meaning of Section 16 of the Health and Safety at Work Act 2015. Commentary. This case arose from deeply distressing personal circumstances for the family involved. The legal questions that the case itself touches upon are questions of trust law that have long been in the contemplation of offshore practitioners. On one hand, trusts are often used as vehicles to own and operate businesses. On the other hand, the orthodox position is that a trust is not a legal entity, but an equitable relationship. It cannot sue or be sued, contract, or incur liabilities in its own name. Only the trustees can do these things, and they do so personally, albeit with rights of indemnity from the trust fund. The majority in the Court of Appeal effectively argues that this doctrinal position cannot be allowed to defeat the practical operation of a regulatory scheme designed to impose duties on whoever is conducting a business. When a trust undertakes the business as a matter of substance, it should be treated as the PCBU. Walter J's dissent, by contrast, insists that substance and form are not intention. The substance is that individual trustees conduct business using trust assets, and trust law already provides a coherent regime for making trusts pay for doing business. Looking ahead. The Supreme Court's decision on the substantive appeal will be closely watched. The critical question is whether the court adopts the long-standing approach that a trust cannot, consistent with established principle, be treated as a person, or a broader purposive interpretation that prioritizes the functional reality of how trusts operate over their doctrinal classification. If the Supreme Court affirms the majority, it will represent a significant doctrinal development, a recognition that trusts, when used as vehicles for business, may be treated as persons for the purposes of at least some regulatory and criminal statutes. If the court prefers Walter J's approach, it will affirm the continuing primacy of orthodox trust principles, while potentially endorsing the novel concept of prosecution of trustees as trustees with recourse to the trust fund.